Hello and welcome to Head and Neck Connect, a supportive space created by the Head and Neck Cancer Alliance, especially for caregivers of head and neck cancer survivors. I'm Melissa Cook, a speech-language pathologist and patient resource navigator for the Alliance. Today, we are thrilled to welcome a speaker from Triage Cancer, an organization that is a great friend and partner to the Alliance. Triage Cancer is a national nonprofit dedicated to providing free education on the crucial legal and practical issues that follow a cancer diagnosis, from navigating insurance and employment to managing finances. We're delighted to have their senior staff attorney, Amanda Goodstadt, with us today. Amanda brings a powerful combination of legal expertise and extensive hands-on experience supporting caregivers. For 12 years, she directly counseled individuals on Medicare and related benefits and has served as a caregiver coach. A graduate of Cornell University and the University of Pennsylvania Carey Law School, Amanda now uses her deep background to serve the cancer community. Please join me in welcoming Amanda.
Thank you for joining me today to talk about legal, practical, and financial issues for caregivers to consider. I'm Amanda Goodstadt, Senior Staff Attorney at Triage Cancer. Triage Cancer is a national nonprofit that provides free education on the legal and practical issues that may impact people who've been diagnosed with cancer and their caregivers. We provide education in a wide variety of ways. We host educational events like conferences and webinars. We create different quick guides, checklists, worksheets, and other written materials. We record short animated videos and podcast episodes. And we offer an individualized legal and financial navigation program. Everything we do is provided free of charge. Almost all of our resources, including our legal and financial navigation program, are available in both English and Spanish. You can learn more about any of our work by visiting our website, triagecancer.org. We work with caregivers who have questions on behalf of their loved ones, as well as questions on behalf of themselves. So, for example, a caregiver may contact us and want to know information about how a loved one can take time off from work for treatment. Or they may contact us and ask about how they, as a caregiver, can take time off from work to support their loved one through treatment. In our limited time today, I want to mention some of the issues caregivers most often ask us about. I'll start off by talking about employment rights, some of which relate to your loved one's rights and some of which relate to your own workplace rights as a caregiver. Then I'll talk about some options for replacing lost wages if a caregiver is unable to work for a period of time because of their caregiving responsibilities. I'll mention some information about navigating the healthcare system and managing medical bills, and then end with some ways to facilitate making financial or medical decisions on behalf of your loved one if they become unable to do that for themselves. When we talk about employment rights, there are a lot of places to go and see what rights we have. There are laws we call fair employment laws that protect people against discrimination in the workplace based on their medical condition and give them access to reasonable accommodations. These laws exist at the federal level, meaning they're the law throughout the United States, but they also exist at the state and sometimes local levels. The major federal fair employment law that I'll talk about today is the Americans with Disabilities Act. In addition to fair employment laws, there are also leave laws that allow someone to take time off from work and provide some job protection and sometimes even some health insurance protection. Those laws also exist at the federal level as well as at the state and sometimes local levels. The federal leave law I'll talk about today is the Family and Medical Leave Act. In addition to all these laws, some people work under the terms of an employment contract. If that's the case, you have to read the contract to see what benefits it does and doesn't include. You could have an individual contract, or if you're a union member, your union's collective bargaining agreement is your contract. Laws just provide the bare minimum of benefits that an employer has to provide to its employees. There are a lot of employers that provide options and benefits that are a lot better than the bare minimum. So it's important to look at your employer's policies also. You can find these in an employment manual, sometimes in other policy or procedure documents. and sometimes online in an employee portal. If you don't have anything like this, speak with your human resources representative or with whomever at work handles employer benefits. Employee benefits that are provided at your work can be wide-ranging. They include everything from health and other types of insurance to paid sick and vacation time, general PTO, and opportunities for things like flex time, job sharing, and telecommuting. On top of information about benefits, other information that's important to find in your employment manual has to do with whether your employer has a process to request a medical leave or really any other kind of leave of absence, or a process to request a reasonable accommodation. Not all employers have these formal processes, but if your employer does, it will be important to follow it. Title I of the Americans with Disabilities Act, or ADA, is where we find its provisions about employment. Not everyone is eligible for protection under the ADA. As with most laws, there are requirements that you have to meet in order to access the protections in the law. First, you have to work for a private employer with at least 15 employees or for a state or local government. Federal employees have similar rights, they just come from a different federal law. In addition to working for the right kind of employer, you have to be a qualified individual. This means you have to be qualified for the job you're doing, and you have to be able to perform its key responsibilities. But to do that, you can get help through something called a reasonable accommodation. And then the last requirement is you have to have a disability within the ADA's definition of that word. So every law that uses the term disability can have a somewhat different definition of what that word means. For the ADA, a disability is a physical or mental impairment that substantially limits one or more major life activities. So let's break that down. First, you have to have a physical or mental impairment. Second, it has to limit a major life activity. And third, that limitation has to be substantial. It can't be something minor or something that only happens once in a while. Major life activities are things that the average person in the general population can do with little or no difficulty. There are things like breathing, sleeping, walking, talking, eating, even the operation of major bodily functions. You could have one physical condition that impacts one major life function, or you could have multiple conditions impacting multiple major life functions. Sometimes it's not someone's cancer diagnosis that creates a disability, it's the side effects from treating the diagnosis. Things like fatigue or nausea, or even anxiety related to the diagnosis that are impacting major life activities. It could be that one of these side effects is substantial, or it could be a combination of side effects that creates the presence of a disability under the law. When we look and see if someone has a disability under this definition, we do it on a case-by-case basis. We look specifically at an individual and how their medical condition is affecting them. Once someone has shown that they're a qualified individual and that they have a disability under the ADA, there are 4 ways someone can access this law's protections. You could currently have a disability. You could have a history of a disability. You could be regarded as having a disability, which isn't really about you so much as about your employer and how they perceive you. And then the 4th way you can be protected is based on association with a person with a disability. This is where caregivers may be able to have protection from discrimination. A caregiver could potentially be treated differently because an employer maybe thinks that caregiver isn't going to be able to take on additional responsibility at work, so they choose not to promote a caregiver. Or they don't give a caregiver a big assignment because they think they're going to be distracted by what's happening for them at home. The ADA is a powerful law. It applies to all phases of the employment process. It doesn't just protect people once they're employed, it protects job applicants also. And in terms of what it does, no matter which way you're using to access the ADA, it protects you from discrimination. Employers cannot make employment-related decisions based on medical information. In addition, If you're someone who currently has a disability or has a history of a disability, you may be entitled to reasonable accommodations. Legally, a reasonable accommodation is any change in the work environment or in the way things are customarily done that enables someone with a disability to enjoy equal employment opportunities. Practically, a reasonable accommodation can be just about anything as long as it is both reasonable and effective. The easiest way for me to talk about accommodations is by giving you examples, and they're divided into three main categories. The first are changes to someone's physical workspace. For example, this could be moving someone's office. Maybe they need to use the restroom all the time, and they don't work on a floor of the office building that has restrooms on it, so they ask to move to a different floor. This could be about getting somebody a closer parking spot because they're fatigued, and their typical parking spot was far away from the entrance to their workplace. This could be about getting someone special furniture or other accessible equipment. It could also be about letting someone work from a different location. Usually people think, okay, work from home, but there are other locations someone might want to work from as well. Maybe they want permission to occasionally work from an infusion suite. Maybe they want permission to work from a different branch of their employer. Maybe the employer has a satellite office that is closer to their home or closer to where they get treatments, and so that would cut down on their commute. Accommodations can also be about changing someone's work schedule. This might be about working part-time or with a flexible schedule. It might be about changing hours or shifts. Maybe somebody is nauseous in the mornings, but they feel fine by afternoon or evening, and they work at a retail business. So maybe they ask to only be assigned afternoon and evening shifts instead of morning shifts. Maybe this is somebody who works on their feet, and so they request additional break time to rest. This could even be about taking an extended leave of absence. And then the final category here is really meant to be a catch-all for everything else. So maybe it involves technology. Maybe this is someone with neuropathy and they have to use a computer all the time. Perhaps there's some sort of application that allows them to convert speaking into typing that eases their issues using the computer. Maybe this is about a change in a workplace policy. Perhaps this is someone who works in a restaurant as a waiter or waitress, and they have a uniform, but they're experiencing temperature sensitivity, so they ask if they can wear a sweater over their typical uniform. This could be about asking to shift non-essential job responsibilities, and under certain circumstances, it could even mean changing jobs within an employer. Subject to limited exceptions, employers are required to accommodate individuals who currently have a disability or who have a history of a disability. They're not required by law to accommodate caregivers. That doesn't mean that it hurts for a caregiver to ask for an accommodation if they need one. I say that because there's data to support the idea that reasonable accommodations don't just benefit employees, they benefit employers too. If an employee is thinking that they need to leave work because of their caregiving responsibilities, an accommodation could let their employer retain them and avoid doing a job search or avoid the cost of training someone new to do a job. Accommodations also can increase productivity and increase attendance. Now I want to turn to the Family and Medical Leave Act, or FMLA, our federal leave law that, among other things, allows an employee to take time off from work due to their own serious health condition or to care for certain family members with serious health conditions. If you're a caregiver, you can only take FMLA leave to care for a parent, a spouse, or a child. It's a really narrow definition of who might be a caregiver. There have been some attempts to broaden this definition at the federal level. None of those has panned out thus far, but you should know that many state leave laws provide a much broader definition of who someone can be caring for. As with the ADA, there are some requirements you have to meet in order to be eligible to use the FMLA's benefits. So first, you have to work for the right kind of employer. It has to be a private employer with at least 50 employees or a government employer. In terms of reaching that 50 employees, you can look at the number of employees who are within a 75-mile driving radius of your work site. So what that means is that if you work for a big company that has multiple offices within 75 miles of one another, you can add up all the employees at all of those work sites to get to 50, even if your particular work site has fewer people. You also have to have worked for your employer long enough to be eligible to take leave. The FMLA requires that you work for the employer for at least 12 months. There is some flexibility in that you can go back 7 years to find those 12 months. So that might help out a seasonal employee, someone who only works a few months during the year, but has come back to the same employer year after year. You also have to have worked at least 1,250 hours during the last 12 months you worked for the employer. You don't necessarily have to have worked full time, but you have to have worked at least that number of hours. The FMLA entitles an eligible employee to up to 12 weeks of unpaid leave per year. You can take those 12 weeks in one long block of time or in shorter periods. You can even take leave intermittently. But the leave's unpaid, and obviously a lot of people can't afford to lose income. It is possible to access an employee's paid leave at the same time that you access FMLA leave. The real benefit, though, to the FMLA is it allows what we think of as a bubble of protection. When someone's using it, both their job and their health insurance are protected. An employee can't be let go for taking FMLA leave, and they have return to work rights. Generally speaking, if an employee is returning from FMLA leave, they have to be reinstated into the same or an equivalent position to what they had before they went out on that leave. This is really important. Generally, if someone takes time off using regular sick time or vacation time, or even someone who's taking time off and accessing short-term disability benefits, none of those things protect their job. And so unless there's some other state law or contract provision or company policy that says otherwise, an employer could let you go during those times, as long as it's for a non-discriminatory reason. FMLA leave also protects health insurance. So if an employer is paying for some or all of your health insurance coverage, they have to keep doing that while you're out on FMLA leave. They can't force you to go on to COBRA. We have a lot of resources on our website related to employment. So if you have more questions on this topic, I invite you to visit our Work and Cancer page. Many family caregivers end up reducing their work schedules or stopping work altogether. And most people can't go without working for long periods of time without some kind of income. Someone who's experiencing their own medical situation might be entitled to disability insurance benefits, but their caregiver isn't. There are some limited options for caregivers who need to take time off from work and want to replace those lost wages. So right now, 14 states offer state paid leave programs for caregivers, or will offer those programs by the end of 2026. Each of these state programs works a little bit differently, but they have some things in common. In general, these programs are funded by payroll deductions and or by employer contributions. Many of these programs may not apply if you're a public sector employee. Some do, but if you're a government employee, you're going to want to check. Many of these programs have an option if you are self-employed to opt in and make contributions to the system so you can access the benefits if you need them. And most of these programs are going to cover people who work in these states. So if you live in a state that has one of these programs, but you work in a state that doesn't, you are likely not going to be covered. The best way to see if you're covered by a program is to check your pay stubs and see whether there have been payroll deductions. One example of how a program works is California's paid family leave program. It provides up to 8 weeks of paid leave in a 12-month period for employees who are taking time off to care for a wide variety of family members. The program is available if you're a private sector employer, or pardon me, private sector employee. It's also available if you're self-employed and have opted in. And after a 7-day waiting period, someone can get around 60 to 70% of their full income, up to a maximum weekly benefit amount that changes each year. It's great that so many states have these programs or are implementing them, but obviously not everyone works in one of these states. 2 other options I want to mention. One is related to Medicaid. So Medicaid has an interest in keeping people in their homes and community-based settings. And so it has developed what it calls self-directed or consumer-directed care programs, where if a person gets their health insurance through Medicaid, they can choose who's going to provide certain types of care, specifically personal care services, things like help with bathing or dressing or going to the bathroom. And they can select certain family members to help with this, and the family members will receive a modest amount of payment for those services. Keep in mind that Medicaid, because of how it's funded, operates differently state to state. So you need to check and see if your state has one of these programs. And also, you need to know that Medicaid often is impacted by state budget cuts. So sometimes, even if a state has this kind of program, it may be low on funds. The Veterans Administration has a similar type of program called veteran-directed care, where if a loved one has VA benefits, they may have a personal allowance that they can use to pay, again, a caregiver, a family member, to provide certain types of assistance with daily living. Another major topic of concern for caregivers is health insurance, understanding options, navigating using the insurance, and managing medical bills. There are a variety of ways people get health insurance in the US, and while I can't get into the ins and outs of all those options today, I do want to emphasize that they exist, and it's important to know about all of them. You might know a lot about one, but being a caregiver may mean you need to learn about another. So maybe you have employer-sponsored coverage, but you're caring for a parent who has Medicare. Or maybe you're covered under a spouse's employer coverage, and your spouse has to stop working, and so you need to learn about COBRA or the marketplace. We have a lot of resources dedicated to helping people understand all these different options. We also have some resources that are specifically about choosing the right plan. This is so important both for accessing care and for your finances. We have information in an animated video about picking a health insurance plan, and we also have a health insurance cost comparison worksheet. There's a special worksheet that we have for people with Medicare because there are some different nuances to how that cost comparison works. Choosing a plan is only the first step, though. To really make sure your loved one can access care and minimize costs, you're going to need to help them make the most of that plan, which includes using in-network providers, making sure that they get prior authorization when that's required for tests and procedures or for prescription drugs, making sure to compare their bills to their explanations of benefits. Be certain that you're not being billed or that your loved one is not being billed for care they didn't get or for things that should be free, like preventive services. Leveraging out-of-pocket maximums. And what I mean by that is knowing when someone has reached their out-of-pocket maximum and trying, if it's possible, to schedule other necessary medical care within the same plan year so it can be covered at no additional cost. And not taking no for an answer. Pursuing appeals when coverage is denied. If you visit Triage Cancer's health insurance topics page, you can find resources that provide additional information about all of these things. I'll just note that when it comes to appeals, a lot of people don't realize they have the right to appeal a denial, or they know they have that right, but they don't take advantage of it, even though appeals often end up in favor of the patient. In most insurance processes, people have two different or a minimum of two different appeals opportunities. One being internal, where they go back to the insurance company that said no and ask the plan to reconsider. And one being external, where you can go to an independent agency and ask them to review what the insurance company has done. Again, we have a lot of resources specifically about process, because the process varies depending on how someone has insurance, as well as practical tips to take when doing an insurance appeal. One resource we have is an appeals tracking form that you can download from our website to keep track of important dates and deadlines and important conversations that you've had. I know some people like that colorful Post-it note method. I always lose the Post-it note that I most need at any given time. I favor this spiral notebook method because I like it when no papers can fall out. And I can always flip back through the pages and see notes on any previous conversation I had. Appeals and managing medical insurance information overall is a great thing to delegate if you have a family member or friend who has been offering to help you out and doesn't know what they can do to be helpful. It is a good time not just for the individual with a diagnosis to delegate, but for caregivers to delegate also. It's a lot of work to be a caregiver, and sometimes you're not going to be able to do every single thing. And so some of this, what I'll call administrative work, may be a good thing to give to someone else who's able and willing. Along those lines, in order for someone to effectively support you, you may need to get some tips about being organized. So for example, consider keeping a lot of this information electronically rather than in hard copy, because it may be easier to share electronic files with someone else who's helping you out. Consider keeping a list of all of your loved one's medications, all of your loved one's providers. Maybe someone else can help you with bringing your loved one back and forth to appointments. Even when those appointments are in the same health system, you are likely to get questions about these types of things. And so it's great to have the information easily accessible and in a place where it can easily be shared with others who are helping you out. Just as a caregiver needs to plan ahead to stay organized about the ins and outs of medical care, they also need to plan ahead legally for situations where their loved one may not be able to make certain types of decisions for themselves. There are a variety of legal documents that you can have in place. The first is a HIPAA release form. So this is a form where a patient can authorize a caregiver or another adult to have the ability to access their medical records. This is really useful if someone is trying to help out with things like health insurance appeals or managing medical bills, or even providing support for an FMLA request or a disability benefits application. A HIPAA release form is going to come in handy. Your loved one can authorize whoever it is that they want to have access to all of these medical records, and then that person will be able to communicate with providers and with the health insurance company. Another type of document that's very useful is a power of attorney for financial affairs. This is a legal document where your loved one, in this case would be called a principal, can name you as a caregiver or another trusted adult as their agent. And the principal can authorize their agent to make financial decisions or take care of financial matters on their behalf. There are both standing and springing powers of attorney. A standing power of attorney takes effect when it's signed, and it continues to be in effect even when the principal becomes incapacitated. A springing power of attorney only takes effect when the principal becomes incapacitated. Why might you want a standing power of attorney? Why might you want to authorize someone to help you with financial affairs even when you still have capacity to do those things yourself? Well, someone might have capacity, but just be unable to get to these things. Maybe they've been hospitalized for a while. They're really tired. They're not unable to make decisions for themselves, but they could use help actually taking care of certain types of transactions. Power of attorney is not a substitute for a will. The power you're giving that agent ends when the principal dies. In terms of the different duties a principal can grant to an agent, they're wide-ranging. That agent could be helping with paying daily bills. They could be helping with healthcare bills. They could be going to the bank to make deposits or withdrawals, filing taxes, managing real estate, managing investments, signing applications for government benefits. They can do just about anything or help with just about anything except for medical decisions. People sometimes assume medical decision-making will only be an issue at end of life. It isn't. There may be other situations, even if they're pretty short in duration, when someone becomes unable to express their wishes for themselves. Maybe it's an unexpected hospitalization or during a surgery. And having certain documents in place related to medical decision-making can make things a lot easier if and when that happens. The primary document, legal document we would talk about in this scenario is an advanced healthcare directive. That has two main components. The first is a living will. This is where someone can express their views about end-of-life care, and it usually is something that only deals with end-of-life situations. But it's the second part of the Advanced Healthcare Directive I want to focus on today, and that is a power of attorney for healthcare. It can be called different things in different states. All of the names on the slide can be used, but this is essentially a power of attorney where a principal, again, names an agent, maybe the same one as the financial power of attorney, maybe someone different, to make medical decisions for them if and when they become unable to express their wishes themselves. It's different from the power of attorney for financial affairs because this one only comes into practice, I should say, if the principal is no longer able to make these decisions themselves. A power of attorney for healthcare that is broad essentially allows the agent to make any and all healthcare decisions that the patient would otherwise be able to make. They can consent or refuse medical procedures or medications. They can hire or fire medical personnel. They can make decisions about whether their loved one should be admitted to a nursing home or to hospice. Your loved one can name one or more alternate agents in the event that the primary agent is not reachable. We never recommend appointing co-agents because having two people with equal decision-making power could lead to conflict or confusion on the part of the healthcare provider. As with all the other topics I've covered today, we have a lot of advanced planning resources. I'll highlight in particular our state-specific estate planning toolkit that has both a lot of great general information about all different types of legal documents involved in an estate plan, as well as state-specific information and even forms that you can print out and complete. Finally, if you're looking for more resources for caregivers, I invite you to take a look at our caregiving webpage, and I look forward to speaking with everyone again. Thank you.
Thank you for joining us today for this important topic. If you have any questions, feel free to reach out to us via email at connect@headandneck.org or visit our website for more details, www.headandneck.org. We hope that you'll join us next week for our online discussion, where you will have a chance to chat with other caregivers and professionals about these important topics. It's an honor to connect with you. Wishing you strength and peace in the week ahead.